Can you all hear me? So we have already started. We're already in the webinar. We can wait just 1 or 2 minutes in order to start. We already have some people here, some attendees, but we have a lot of them are entering now, actually. So we can wait 1 2 minutes. Yeah, people are entering now. Yeah, it's 2 o'clock now. Yeah, the number is increasing, so yes, I think it's good that we wait 1 more minute. And as we have a lot of people that are in the United States, in Latin America, and there it's much earlier. Okay, so I think we can start now. We have several people at this moment, and it's already 2, so I think it's a good idea to start. Okay, so welcome everyone to our webinar, Ship Sets Sail to Discover Trademark Hot Topics Around the World. My name is André Sarmento. I work in Ship Global IP, as you can see here, as an IP agent in the European Union. My experience is mainly in trademarks, and I've been working in intellectual property since 2014, so for 7 years now. I would like to start our webinar by thanking all our speakers and the fact that they accepted our invitations. We are very eager to listen to their experience and to their insights in their countries. So I would like to start by introducing the 3 speakers that we have. We have our speakers are from China, US, and Europe, more specifically Spain. So I will start to introduce our first. I will start by introducing our first speaker. So Ying Wang. Ying Wang is an attorney, trademark attorney in China, more specifically Unitali Attorneys at Law. Ying has over 18 years of experience in trademark proceedings, administrative protection of trademark rights, trademark litigation, and trademarks strategy in China. Ying has a master's degree in law from Law School of Renmin University. And yeah, I think we all want to hear from her what's happening now in China regarding the trademarks. We will then have our second speaker. So I'm giving you the order of our webinar. So first we will have Ying, then we will have our second speaker, Lian Leglater. So Lian Leglater is our second speaker and has been practicing IP law, intellectual property law, for 15 years, around 15 years. He's a partner at Jenkins, Wilson, Taylor and Hunt, a boutique IP firm in the famed Research Triangle Park region of North Carolina, USA. Lian Lian practice mainly on counseling clients in trademarks and patent law. Lian enjoys working with a range of different clients, such as startups, renowned universities, and large corporations. We will finally have our third speaker, Sergio in Spanish. So Sergio is Spanish and is the founder of the IP boutique, the European IP boutique, Iberian IP. He started working in IP for around 15 years now, so it's more or less the same time as Lian. He has a large experience in comprehensive strategic advice on all industrial and intellectual property matters, not only in Europe, but also in Latin America. And he works closely with domestic and international clients. After introducing our speakers, I would like also to tell you that we will have a Q&A at the end of this webinar. So we will be able to, since now, start to making questions to any of our speakers, and we will read them at the end of our webinar. I will ask them your questions. If we don't have time to answer all the questions that you have, we will send you an email with the answers. So don't worry if we don't have the time for that. Then I would like also once again to thank you for being in our webinar. As you know, or as you might know, we have people from a lot of different countries and continents. As you can see here, we have mainly 3 very different time zones. We have a lot of attendees that come from Latin American countries and the US, where they have similar time zones, and they are probably having their coffee now. So good morning to all of them. We have a lot of European people, as you can see in the middle of this map, and where I am too, in Spain, where we just had our lunch, or we will have lunch in some after the webinar, because in Spain people tend to have lunch a bit later. So good afternoon to all of that people, to all of our European attendees. And finally, we have a lot of people from different Asian countries attending our webinar, not only China, but also Malaysia, Indonesia, Japan, a lot of different countries. And there, in these countries, people have had just their dinner for sure already. So I would like to tell you good evening, and thank you again, once again, for being with us. At this moment, I think it's everything from my side. So I would like to hear now from, I think we all want to hear now from Ying and her experience in China. So Ying, I think I will give you the control now to start your presentation. I think you can start now.
Hello, Andrew. I cannot control the slide. Hello.
Let me just see here.
Yeah, I cannot control the slide.
I think you can now. If you can try now, Ying.
No. Okay. Oh, okay.
Okay.
Yeah.
Sorry.
Thank you, Andrew. It's my pleasure to share a presentation on China part. My topic is about impressive growth in trademark registration in China and how to register a trademark in China. First, let's see some statistics about trademark filings before China Trademark Office, CTMO, from 1998 to 2020. The statistics are available from CTMO's annual work reports or news reports in China. From the chart, we can see the number of trademark applications received by CTMO each year increased significantly and nearly constantly. Last year, CTMO received over 9,300,000 trademark applications. The number is at a record high. Among the applications, 98.5% of them are from domestic applicants and 2.5% from foreign applicants. From 2017, the filing amounts went up above 5 million, partly because CTMO cut the official fees from April and introduced e-filing services that year. When China prepared to join the WTO in 2001, it amended its patent, copyright, and trademark laws. the amended trademark laws took effect on December the 1st, 2001, and lifted restrictions on individual applicants. So annual filings increased rapidly from 2002. But in 2007 and 2008, the filings declined slightly, partly because the CTMO tightened the standards of documents for Chinese individual applicants from February 2007. This is a brief overview of annual growth in trademark applications in China in past 22 years. By the end of 2020, there were more than 30 million valid trademark registration in China. Now, let's have a quick look at top 3 trademark filers in China last year. The first is Tencent, an internet-based company. It's the world's largest gaming company and owns WeChat, the most popular social media app in China. The second is JD.com. It's a massive e-commerce platform. The third is Huawei, a big Chinese telecommunication and electronics company. Now let's see the factors driving trademark filings in China. The biggest factor is China's rapid economy growth. Since China began to open up and reform its economy in 1978, GDP growth has averaged almost 10% a year. China is now the world's largest manufacturing economy and exporter of goods. It is also the world's fastest growing consumer market and second largest importer of goods. Second, promoting IPR creation, application, and protection is our national strategy. Chinese government carries out a series of policies, actions, and plans to build a stricter IP rights protection system. The awareness of the entire society to respect and protect IP rights has significantly improved over the years due to publicity and education on IPR protection. It's commonplace to do business with a trademark in China. Because of the development of technology, it's easy and fast to file trademark applications in China. According to CTMO's statistics, over 98% of all trademark applications are filed online. Other factors, there are bad faith applicants without intent to use trademarks. They file applications for investment and speculation. After getting registration, they actively sell the marks to others, force others to cooperate with them in trade, ask for high compensation for trademark assignment, license, or infringement damages. To crack down on malicious filing, China amended its trademark law in 2019, and CTMO has kicked off the campaign and rolled out a series of rules. According to the new rules, CTMO can directly refuse the applications that are suspicious of bad faith filings at the stage of examination. On the other hand, there are good faith applicants. They file defensive applications. Let's see some big changes in past 5 years. CTMO is deepening reforms to facilitate and streamline the process of trademark examination and registration. It has introduced e-filing services from 2017, online filing, online notification and response, online search, and online payments are available. Other friendly measures include setting up windows all over the country to receive trademark filings, simply filing documents, opening green channels to expedite examination of some applications, reducing official fees. CTMO cut official fees by a half from April 1st, 2017, and offers a further 10% discount for e-filings, shortening examination time. It takes about 4.5 months on average for CTMO to complete examination of a trademark application now. In the past 5 years, the CTMO completed examination of more than 32 million trademark applications. In the next 5 years, CTMO will focus on guiding rational growth in filings, improving the quality and efficiency of trademark examination. How to register a trademark in China. China is a first to file country. If a brand owner decides to protect its trademark in China, I suggest filing the application as quickly as possible. There is no use requirements for trademark filings, but after a trademark is registered for more than 3 years, it is vulnerable to non-use cancellations. When deciding the trademark to be filed, I suggest also considering a Chinese version mark, because a corresponding Chinese mark is easy for the brand owner to market the goods and services in China, and it is convenient for Chinese customers to recognize and memorize the foreign brand. Some foreign companies produce goods in China and then export them. They do not sell the goods in China. It is still necessary to register mark used on the exported goods in China. Otherwise, if someone else registers the mark and records it at General Administration of Customers, local customers might block and seize the suspected shipments. The exporter might face the risk of trademark infringement. To improve the chances of successful registration, the trademark shall meet the requirements of China trademark law. For example, the mark shall be available to use, distinctive enough to identify the origin of goods, different from others' prior trademarks, and without negative influence or deceptive meanings. Before filing, it is advisable to conduct availability search to find out any obstacles. I suggest entrusting local experienced attorney to do the work and taking proactive measures to remove obstacles located by the search. Finally, there are 2 options for filing a trademark applications in China. One is domestic application before CTMO. The other is international trademarks through Madrid system. CTMO implements the same examination standards, and examination time are similar. After registration, CTMO shall automatically issue a certificate to domestic mark. But for international mark, applicants need to apply for a certificate separately, and they have to wait to file the application until the 12 or 18 months of examination periods expire. So extra time and cost will occur for protecting an international mark in China. I think this is all I have on China part. Let's welcome Lian to present US part.
Thank you, Jing. All right, good day, everybody. It's good to be here. Thank you, Andre, and your team at ShipIP for putting this together and inviting me to speak. So I'm going to talk about, can everybody hear me okay? I'm going to talk about the Trademark Modernization Act, which is a new act in the US and will be changing some of the things we do from a trademark perspective in the US. So I think it's important that we all start to become familiar with this. So it was passed by the US Congress on December 27th of last year. It was actually part of the coronavirus relief bill, which is not unusual in the US for large pieces of legislation to include, other somewhat unrelated acts. So that's kind of how this came to be. It amends the Lanham Act, or formerly known as the Trademark Act of 1946. The Lanham Act is what controls the trademark law in the U.S. So it amends that in several places, and we'll talk about a few of those key changes here in a minute. Excuse me. It's set to be fully implemented December 27th of 2021. So here in just a few months. The creation of the regulations and rules that actually implement the TMA, those have been charged to the director of the USPTO, which is fairly typical. And so the USPTO has put together some proposed rules to implement the Trademark Modernization Act. Those are currently open to public comment, and there are several forums and mechanisms by which you can comment and provide feedback on the proposed rules. Although that comment period is closing soon, it's you have to send those in by July 19th of 2021. So a couple weeks left to send in your comments if you wish to do so. Let's see if I can change the slides here. There we go. Okay. So the key changes to the Lanham Act, there's three I want to talk about. One is TMA provides new mechanisms to remove used or improper trademark registrations. Secondly, it changes some of the procedures during the prosecution phase. And thirdly, it clarifies the evidentiary burden to obtain injunctive relief during infringement actions. So those are the three big areas I want to talk about today. The first one is it provides new mechanisms to remove or cancel unused trademark registrations. They could either be, sometimes they're fraudulent, other times they're just inaccurate based on their use in commerce. This, I think, was included in the TMA in part because there's been an increasing number of fraudulent trademark registrations. There's two key mechanisms that have been introduced to achieve this. There's a new expungement procedure and a new re-examination procedure, and we'll talk about those here in a moment. So first off, the expungement procedure, and this is where a registration can be challenged on the basis that the mark was never properly used in commerce. And in the US, like many other countries, there's a requirement that the trademark be used in association with the goods or services, and you have to demonstrate that use to have a valid registration. So this is to use this procedure, the expungement procedure. A petitioner would file a petition. They would have to supply evidence of non-use after a reasonable investigation. It's still not clear exactly what reasonable investigation entails, but I assume we'll get some more details or examples of that in the future. You can request to cancel the registration with respect to some or all of the goods and services. This is one way to look at this is it's perhaps an alternative to the current cancellation proceeding. And one of the key things to remember here is that the expungement petition to expunge must be filed between 3 and 10 years after the registration. At least that's the current rule. And remember, everything we talk about today, these are all the currently proposed rules by the USPTO. They're not final yet, so some things could change based on the comments that they receive. And then secondly, the new re-examination proceeding is another alternative mechanism to remove marks. And this will be based on an assertion that the mark was never used in commerce prior to a relevant registration date or prior to your recorded first use date. Again, this will be based on a petition filed by a third party. Again, the petitioner must supply evidence after a reasonable investigation. And like the expungement procedure, you can request to cancel some or all of the goods and services in the registration. One of the biggest differences here is that the timing of the filing, and for the re-exam, it has to be filed within the first 5 years after registration. Or again, at least that's the currently proposed rule. So, all right, so the second piece of the TMA that I wanted to talk about was some changes in the procedures during the prosecution phase of trademark applications before the USPTO. The TMA talks about creating some mechanisms to make the response periods to office actions more efficient. And the rule actually talks about giving the Act talks about giving the examining attorneys flexibility to set response times, and notes that they should be at least 6 months long in total. But the USPTO proposed rule is a bit more specific, which is probably good. The proposed rule is to give applicants 3 months to respond to an office action, with a one-time extension obtainable for an additional 3 months. So you still get 6 months to respond to an office action, but the initial deadline would be set at 3 months. The goal here is to just move things along more quickly once we get into that prosecution phase, which I think is probably a good thing. Similar to China, the number of filings in the trademark office has gone up significantly the past year or so. So there's a bigger backlog. It's taking longer to get office actions. So once examination really gets started, this rule will help it move along more quickly, which I think is favorable for everybody involved. Do note, though, that currently the USPTO rule for this aspect of the TMA will not take effect until June 27th of 2022, so a little bit later than the rest of the rules. Okay, another piece of this change in procedure, there's a proposed rule to formalize the third-party submissions. So third parties under this rule, can submit evidence into the record of an application if that evidence is tied to a particular ground for refusal. So during the examination phase of an application, a third party can submit evidence, say, for example, like a likelihood of confusion issue. So you would, as a third party, you'd have the ability to submit that and make that of record. Okay, and then the third, I guess, component that I wanted to mention today with respect to the TMA is there's a section that clarifies the evidentiary burden to obtain injunctive relief in trademark infringement actions. So the Act specifically clarifies that irreparable harm can now be presumed in litigation where injunctive relief is requested. This was necessary. It was necessary to put this to codify this because there was a split in decisions among some of the U.S. appellate courts. Some presumed the irreparable harm, others required a showing of irreparable harm. So because of that split, Congress stepped in and clarified that aspect. So that was the intent there and the reason that was included in the TMA. And some folks think that this was really the driving force in getting the TMA pushed through. So to kind of tie all that together, I'll lastly just mention that here's a few maybe takeaways or potential practice tips with respect to the TMA. And remember, nothing's finalized yet. So, kind of we'll have to keep monitoring this as the rules become final and come into play later this year. So some of these things may change slightly, but at least based on what we know now, some things to think about would be to, consider the new expedited procedures to remove fraudulent or otherwise incompliant registrations, particularly the expungement proceeding and the re-examination proceeding. So those are a couple new tools we can use. It'll be important to become familiar with the new response periods for office actions. So, currently, as I mentioned, they're proposing to change it to a 3-month period. So we'll have to, be familiar with that and make sure we're docketing things correctly with that new response period. The other new tool we had to think about using is the ability to submit third-party evidence in trademark applications, particularly if there's a registration or an application for registration that could be problematic to your client. Use that mechanism to submit evidence if it's warranted. And lastly, with the reduced evidentiary burden for trademark owners, they may consider injunctive relief sooner in disputed matters now that that's been clarified. So those are some tidbits that you might be able to use with respect to the USPTO for trademark matters in view of the TMA. And I think that's all I had to discuss. So I'll turn it over to Sergio. He's going to talk to you some about trademark matters that are going on in Europe. Thank you all.
Thank you, Leon. Good morning, good afternoon, and good evening to everyone, because probably there's people worldwide listening to us. My topic will be divided a little bit between the routes of protection in Europe, also the Brexit and how it affects UTM and international trademarks. That we know that everybody's talking now about the Brexit, but it's always good to know about that. I'm just checking. Okay. Now the three ways to protect trademarks in Europe are mainly national trademarks, going country per country. The international trademark, when you can select directly country per country, as well as the European Union. And finally, of course, the European Union trademark, that formerly called the community trademark. All these ways to obtain the protection are complementary. That means that you can use one of them, the three of them, in fact, and select it. All depends of the client's interest in any time. Firstly, the national trademark, as said, you must go country per country, taking effect just in one country. Of course, this is the worst part for the clients in case they are interested in several countries. It will be not cost effective, and you need probably different documents in all countries. All European countries have national trademark offices, except Belgium, Netherlands, and Luxembourg, that they are acting in the same office, as call it Benelux Trademark Office. The probably most attractive way to protect trademarks in Europe is the international trademarks, because you can cover now 124 countries worldwide. Of course, you can cover all European countries. With international trademark, you can select all the countries of interest for the client, including the European Union. And even if the client is interested later in more countries, they can request extension of the registry to these other countries of interest. Of course, with the extension, all the effects of the trademark, in the moment that the extension is requested, will begin the new protection. All this international trademark is handled by the WIPO. All the regulated filing of the registration is through the Madrid Protocol, and is mainly refers to formal and administrative matters. That means just application, renewal, change of ownership, this kind of matters, until the registration. For all the substantive issues of the international trademark, the applicant must go country per country. So you will have to take care about national, it will be treated as national trademark, taking care of each legislation of the countries selected. And of course, each territory will determine if the trademark is registered or not. They will need to have this in mind, bear this in mind, because it's possible that you file an international trademark and one country does not allow for different reasons, mainly by oppositions. One of the probably of the most famous is the European Union trademark, because with one single application, you can cover the 27 countries of the European Union. It used to be 28, but after the United Kingdom left the Union, it remains to the 27. The European Union trademark is handled by the EUIPO, the European Union Intellectual Property Office, that is based here in Spain. And the good thing is that one administrative way to proceed with the 27 countries. And if there is any issue, even you can then jump to country per country. So it's also cost effective for the client as well as the international registration. What happened with the Brexit and the European Union trademarks, as probably everybody knows now, the United Kingdom left European Union, and they left a transition period for the trademarks that ended last December 31st of 2020, either for European trademarks and for community designs. After that date, since January 1st, 2021, what happened is the European trademarks and designs has no effects in United Kingdom, and in case the clients will be interested in United Kingdom, they will need to apply national trademarks. New application, of course, they will not have, new application of European trademarks will have no effects in United Kingdom after that date. And no oppositions or nullity actions can be filed against United Kingdom trademarks based on European Union rights. These open different situations of the trademarks. The first one be the European trademarks that were registered in December 31st, 2020. There was no problem with this kind of trademarks, since automatically were registered in United Kingdom, as they call clone trademarks, and they automatically copy all the data of the European trademark as United Kingdom trademark. There were no registration issued, but the clients, the owners, could apply for registration to be sure that all the data were already copied. Another option, another situation is the renewal of European trademarks that expires after January 1st, 2021. They will need, all the European Union trademarks will need to be independently renewed in the UKIPO, the UK Trademark Office, in case the clients will be interested in UK protection. This has to be even if the European trademark has been renewed before December 31st, since this is within the 6 months prior to its expiration. At this point, there are not several trademarks in this situation, and it ends, in fact, tomorrow, June the 30th. The most common situation, besides the registered European Union trademarks, is the pending European trademarks as December 31st. In this kind of trademarks, if the owners were interested in UK protection, they must file national trademarks in United Kingdom, paying the corresponding fee to the UK office. And the good thing is that they can claim the date of application of the European trademarks, including the priority dates. In this kind of trademarks, the UKIPO will examine the trademark, keeping, of course, the priority dates claim that must be claimed in the application. And all these requests had as a deadline that September 30th, 2021, this year. So it just in a few months, this deadline will apply. As said, this applies European Union trademarks as well as community designs. With community designs happens nearly the same. All the community design registered in December 31st automatically were cloned in January 1st, 2021 in United Kingdom with the same data of the community design. Even all have requested delayed publication, were not converted in designs in the United Kingdom. What happened with the pending applications of community designs that at December 31st were not registered happens as well as the European Union trademark. They have requested the registration in the UK, and the deadline is September 30th. So in this way, they can keep the date of the application as well as any priority claim, but they need to file the application in UK, proceed with the pay of the fees of the UK office, and they must claim the date of application of the community design in case they want to keep it. If they not claim it, they will not have the priority date. And of course, as well as with the European Union trademarks, will be examined by the United Kingdom office. What happened is with the unpublished registered community designs, in the community designs, you can select to defer the publication. In all these designs, they will need to be registered in the UK unless the publication was made before January 1st, 2021. So you can have the registered community design, but if it was not published, you will need to file United Kingdom design. All these conditions are the same as with the pending, as explained in the pending designs. What happened with unregistered community designs on the date of the December 31st is that to be maintained all these unregistered designs in the UK, they apply the remaining period of protection as formally says continuing unregistered designs, having the same effects as the unregistered community design. All these protections has a limited time of 3 years from its publication, so they will need to wait for the publication to begin with the protection. There will be also the unsupplementary unregistered design right. So that means that since January 1st, 2021, all the unregistered designs released in the UK will enjoy the protection equivalent to unregistered community design. So it will be just an exception and will take effect automatically from the date of disclosure in the UK. It is very important to know that the unregistered designs that are disclosed in the UK as of January 1st will not produce effects in Europe. And European unregistered designs disclosed as of January 1st will not produce effect in the United Kingdom. So it's very important to know that the main dates are December 30 in 2020 or January 1st, 2021, because it's like the date to split everything. Finally, the UE designation in the national trademarks, it's important to mention because United Kingdom is no longer the member of European Union, but remains member of Madrid Protocol. So the people ask what happened with international registration of the trademarks in the European Union and in United Kingdom. The EU designation registered and not rejected by the UEPO have become automatically trademarks in the United Kingdom, but they are not extensions of the international trademarks. They will be treated as national trademarks. So the administrative way, all the prosecution will be substantially different. And the renewal of the international trademark in the UK must be automatically go through UKIPO, because as national trademark is independent and the renewal cannot be done directly on WIPO. All this applies as well as other administrative procedures as change of ownerships and licenses, for example. And the international trademarks with designation in the European Union that they are still pending will follow the same way of European trademark applications pending. The applications, in case the client is interested, needs to be expressly requested in the United Kingdom, because if not, there is no protections there. And they will have until September 30, 2021 to have it. As well as the mentioned with the regular designs and the European Union trademarks, they will need to file directly application in the United Kingdom. They pay the corresponding fees in the UK. And if they want to have it considered, they have to claim the date of the application of the international trademark. And on my side, this is the main situation here in Europe about the trademarks.
Thank you very much, Sergio, and thank you very much, Ying and Lian. I think it was very interesting to hear from you. So I think that a bit before we answer some questions that our attendees have for all of you. We already have some questions actually for all of you. I think at least we will have time for one question for the three of you. I would just like to tell you, meanwhile, I'm looking at those questions, that SHIP has a new trademark management module where you can request an immediate estimate, an immediate quote for trademark registrations that cover around 200 jurisdictions around the world. So I would like to show you just a video of 1 minute and 15, 1 minute and 20 about our new platform. I think that one of the main features is that you can have, in just a matter of 1 minute or 2 minutes, a comparison between the costs of going forward with a trademark via Madrid protocol or via a direct registration. So I think that that can be interesting for some of you. We have some law firms, some IP firms, and some companies that have a lot of trademarks here with us today. So I will show you the video and then we will proceed to the Q&A session. So this was a video that covered our platform. If you're interested, any of our attendees is interested in knowing a bit more about our platform, we can schedule a demo. Of course, we'll give you our contacts, so we can schedule that if you think it would be interesting. I think now we can start with our Q&A session. We have some questions here, and I think that it would be interesting probably to start with our first speaker. That was Ying, because we have one question from Carlos from Brazil here for Ying. He makes a specific question about China. Ying, he's asking, so he says that, so when protection is obtained in China through an international trademark, is it necessary to request a certificate from the China Trademark Office to give value to this protection?
Yes. Yeah. You know, after the trademark owner file an international trademark, China Trademark Office will receive the application from WIPO and examine the application. They made the decision. After the international trademark is granted protection in China, the owner shall apply for a certificate of the mark, because if the owner wants to enforce its trademark, a certificate, registration certificate issued by CTMO is necessary. And if the owner wants to sell the goods online, For example, they would like to set up an online shop in Jingdong.com. Then the e-commerce platform will also need a certificate issued by the CTMO. So it's important to get the certificate. That's the proof of the rights in China.
Okay, so it's not direct. You have to request that certificate. Okay, very interesting. When it comes to Lian, we have a very interesting question too here from Michael from the UK. He is asking, what do you mean by evidence of non-use? So what will be considered as evidence of non-use? That's what Michael.
Yeah, okay. Thank you. That's a good question. So I imagine, so typically when you file a trademark application, you have to submit specimens of use. There's several examples of what specimens can qualify. The specimen usually, for example, could be a screenshot of a website that has your trademark and it shows you selling the goods, for example. Would be a fairly typical type of specimen. So if you're going to challenge whether something was used or not, you might challenge the validity of the specimen itself. You might challenge whether the specimen actually adequately shows use in accordance with the trademark rules. And unfortunately, not all the time, occasionally there's some fraudulent activity too. Somebody can, essentially fabricate a specimen to try to show use. So it kind of depends on the situation, but I expect that typically the evidence you're going to submit to show non-use or improper use is going to have something to do with the specimen that was submitted and whether or not it kind of meets the burden of demonstrating that use or not. And sometimes it may be a case of where maybe there's multiple classes of goods, for example, with the registration, and perhaps you may be just challenging whether the evidence of use is sufficient for all the classes. Maybe it's okay for some of the classes, but perhaps maybe for one of the classes it's just not quite good enough, and maybe you're challenging that aspect of it. So that could be a case I could see happening.
Thank you very much. Thank you very much, Lian. So now we can go for a question to Sergio from Jim from Singapore that is asking, so how do proceedings work before the UK office when we're talking about registered European trademark? I think that yours. Yeah. Oh, okay.
You can hear me now. The things is that all the proceedings before the UK office based on registered European Union trademarks will not be affected and automatically be updated with the trademark rights in the UK. So all these procedures will automatically be separated, and even with some more substantive matters, more complicated things like oppositions and nullity actions filed in the UK and based on pending European Union trademark applications. The UKIPO and agree with the UIPO that will be suspended, and they have a period of time will be for granted of the trademark to be applied for in the UK, and to allow the procedure to continue. So with all these substantive procedures, they open the hand, as we usually say in Spain, and leaving the option to have UK national trademark and then continue the procedure that was previously began in the UIPO.
Thank you very much, Sergio. I think we have time still for at least one more question. So I would like to ask Lian. Maite from Spain is asking, she's actually a colleague of ours. She's asking, how should we advise the client, the applicant, when he hasn't decided yet whether he makes a direct trademark or he goes via Madrid Protocol or any other similar concepts that we have as the Madrid Protocol. So basically, how do you usually advise your clients when they haven't decided between filing directly or not?
Filing directly in the U.S. Well, it's going to depend on where you're using it and when you've started using the mark. So if you're using the mark in the U.S. Currently, you can file directly. If you want to rely upon an earlier priority date, the Madrid Protocol might be helpful for that aspect of it. It's going to largely depend on what your plans are with the mark and when you use it or when you plan to start using it. Might impact that decision. Those are some of the factors that I would consider if you're deciding between the Madrid Protocol versus direct filing in the U.S. And also whether or not you want to rely upon an earlier priority date might be another factor to consider.
Okay, thank you very much, Leon. I think that in order to finish on time and our attendees for sure can have other things planned for their day. I would like to thank all of you and say that I appreciate a lot the fact that you, the speakers, and our attendees were here today to speak about trademarks in China, US, and Europe. I think it was very interesting for all of us. So as I told you before, now I'm talking with you, the attendees. As I told you before, at the end of this webinar, we will answer the questions that you asked by email, the ones that we weren't able to answer. However, you have our contacts here, and we will be able to talk with you and to clarify any questions that you might have also after, if you remember something that wasn't covered here today or that you would like to be clarified. So thank you all. I think it's all from us. Thank you very much, and I hope to see all of you in other opportunities and other events that we'll have in the future.
Thank you, Andre.
Thank you all.
Thank you very much.